Thank you, Madam Clerk. Good morning, everyone. This is the June session of the Tennessee Court of Criminal Appeals here in Knoxville. The panel today, to my right, Judge Robert, your left, Robert L. Holloway, Jr. from Columbia. To my left, your right, Judge Robert H. Montgomery, Jr. From Kingsport, Tennessee. And my name's Robert Wiedemeyer. I'm from Nashville, Tennessee. And I grew up in Oak Ridge, though. Every time I'm over here, I like to point that out because I know how well respected everything about Oak Ridge is, especially in Knoxville. And when we were growing up and beating them every Knoxville school in every sport imaginable and being the envy of all of East Tennessee. But perhaps I digress and exaggerate all in one sentence. That being said, we have read the briefs. Most of the lawyers have been here before. We've got 20 minutes. You have 20 minutes per side. If you wish to, by the way, we often didn't beat Dobbins Bennett or Science Hill or some of those Kingsport schools. Those were close games. I knew you'd want to know that as well.
Thank you for clarifying the record.
Certainly. So that was a pretty long time ago, so the fact that I even remember where I went to high school is pretty good. We're using the light method to keep up with time now, which makes it easier on us, and hopefully it'll work out fine for the attorneys. I think that's all the preliminary announcements I need to make. Madam Clerk, are there any preliminary matters on the docket?
No, Your Honor.
All right, if you would just call the first case, we'll get started.
State of Tennessee versus Timothy Eugene Wells.
Morning, Judge Holloway, Judge Montgomery, Judge Wiedemeyer. Kendall Stivers Jones on behalf of the appellant, Mr. Timothy Eugene Wells, from the Appellate Division of the Public Defender's Conference. Judge Wiedemeyer and Madam Clerk, with the court's permission, I'd like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
Thank you, Your Honor. This case before the court is solely here on a sentencing issue only, and specifically the decision of the trial court to order a sentence of total confinement rather than probation or split confinement. Today we're asking this court to reverse and remand the decision of the trial court because it abused its discretion, specifically by conducting an erroneous assessment of the proof when it decided to order a sentence of total confinement on Mr. Wells. Very briefly, I know the court's familiar with the briefs, but in this case, Mr. Wells was indicted on a charge that was, he pleaded in this case to a lesser offense, namely sexual battery by an authority figure. So this proceeded to a sentencing hearing. A psychosexual evaluation was done as was required for the pre-sentence report. Mr. Wells produced several character witnesses, including the doctor who performed the psychosexual evaluation. And at that hearing, the trial court determined not only that Mr. Wells was dishonest with the doctor in the psychosexual evaluation, but that that fact led to the conclusion that Mr. Wells was not a low to moderate risk, as the doctor purported. We are arguing today that the trial court had an erroneous assessment of the proof in 3 different ways. First, the trial court made an incorrect finding or incorrect findings about the nature and the information that fueled Dr. Adler's psychosexual evaluation, which resulted in a report that Mr. Wells was both treatable for his sexual deviance and that he would be able to be a low to moderate risk upon release into the community. The second was its characterization of the factor of whether or not Mr. Wells would have a sentence of confinement would have had a resonant effect with a discrete population in the community. And third, the trial court erred when it determined that the facts of the case were essentially so egregious or so out of the norm for what was necessary to establish the elements of the offense that total confinement was warranted. Now, we've highlighted the various portions of this in our brief, and if the court has any specific portions of the brief or our findings that we cited in the record, I'll be happy to answer any questions. But the main takeaway from this that we would reiterate to the court, an argument in excess of our brief, was that the trial court repeatedly found that Dr. Adler, who is the gentleman who not only has been a psychosexual provider since 1985, he's on TDOC's Sex Offender Treatment Board. So Mr. Adler, Dr. Adler, states that Mr. Wells is treatable. The court specifically focused on the fact that Mr. Wells denied being inappropriate with another one of his stepdaughters. That conduct was not charged, although she did testify in the trial court, as it was in its purview, considered it as uncharged conduct of which there was enough to substantiate it so that it could enhance its sentence.
Let me ask you one question about your three
Yes, Judge.
factors. The third one, I'm going to start with the third one. The facts were so shocking, horrible, egregious that only incarceration would avoid appreciating the seriousness of the offense. Now, the trial court, of course, we haven't read the record, but the victim testified, if I'm reading it correctly, that she suffered, or is it insecurity, depression, anxiety, post-traumatic stress disorder, and that she required therapy as a result of this approximately 7 years of sexual abuse. Is that correct?
That's correct.
And if that was the testimony in the trial court, I don't know if he actually accredited or he just adopted it, doesn't that clearly support that factor?
The trial court did accredit it. And to that, we've cited two cases. They are pre-bias cases, I'll note for the court. So the standard of review when the court was reviewing these was de novo rather than abuse of discretion when finding that the trial court, when it was examining the trial court's decision. But we've cited two cases that both focus on what we would describe as an egregious factor of that this was behavior that continued for a number of years before it was discovered. So not necessarily one instance that was able to satisfy a single count of sexual battery by an authority figure, but years of conduct that resulted in a single charge. And to that end, we would direct the court to look at the case law that we've cited. I think Buckner was one and Oakes was another, in which there was continuing conduct, and in one instance, conduct that continued after the victim reached the age of majority, and they continued that relationship. And the trial courts found that partial confinement or split confinement was appropriate in those cases, and it was not so egregious.
And what was the proof that the trial court had at the sentencing hearing concerning the sexual abuse of the victim's sister?
So the victim's sister, there were 3 siblings, 2 sisters and a brother. The proof with the sister, which was the conduct that was not charged, was similar to the conduct of the victim in this case, that Mr. Wells waited until their mother was gone or working on Saturdays. There was inappropriate groping or touching of breasts or genital area, and that this behavior stopped when she moved out of the house after the younger sister lodged a complaint. It was investigated. The child abuse or the child services closed the case without any finding, and the sister actually recanted her statement later. That said, the trial court accredited her testimony, and that we're not arguing that the trial court did not have the ability to do that. But that was the nature of the other uncharged conduct. So similar, but without without the force of a charge behind him. And in directing this court to, I'm not directing the court, we would ask the court to pay clear attention or to at least consider the testimony of Dr. Adler. This is, the facts of the case are not great. The charge is not one that someone, or particularly a judge, is going to be likely to give a sentence that does not involve jail time. We're not unaware of that. But the fact remains that the proof here showed that if any case was eligible for probation or any kind of suspended sentence, that the proof here sustained that. And the trial court, in examining and assessing Dr. Adler's proof in the testimony of the community network that he had, and whether or not the court had the opportunity to look at someone who was treatable for this problem rather than simply putting them in prison for 8 years. If ever there was a case for that, it was this case. Dr. Adler noted repeatedly that Mr. Wells, even if he did not admit, and it was uncharged conduct, so he did not admit or did not tell Dr. Adler or the court that he had ever done anything with the sister against whom there were no charges, but he did frankly admit on several occasions that he was inappropriate with his other stepdaughter, that he expressed remorse. The trial court found not only it was free to discredit whether or not Mr. Wells was sincere, but the trial court noted that he expressed no remorse, and that's simply, the expression was there. Whether or not the trial court believed it was another question. And the trial court on multiple occasions stated and found that Dr. Adler was essentially made his report on Mr. Wells as treatable and someone whom had a good prognosis and was a low to moderate risk for reoffending and in a danger to the community. The trial court repeatedly found that Mr. Wells had been dishonest with the Dr. Adler, and that had misinformed Dr. Adler's report, which the trial court then disregarded that portion in determining whether or not Mr. Wells was a risk. And we would argue that the record simply does not support that finding at all. On multiple occasions, and even in his report, Dr. Adler said that he considered that, and in his 30 to 40 years of experience, that was not something, even though it appeared that way to the trial court, that was not something that meant that Mr. Wells was a risk to reoffend or a danger to the community.
I know he pled to the sexual battery by an authority figure. What was he originally charged with?
He was originally charged under the continuous sexual abuse statute.
And is that non-probatable?
It would be. I believe it enhances it to an A, so by nature of the range, it would not be. And I believe the charges in which that made up that charge were not either.
So he pled to, it would be a C, I guess.
Yes, Judge.
And it was probatable. The other question I had is that pled, though, is a range 2 offender, correct?
Correct.
And so doesn't that affect to a certain degree I guess initially how a judge can look at a defendant?
Absolutely. Now, if he's pled out of range in the Hicks plea and he's pled as range 2, then that favorability for probation goes out the window. He still has to establish full suitability, but the judge is no longer required to or bound to that.
Did the judge talk at all about the fact that, he could have been found, he was charged with an offense that could have carried as an A, but you've agreed to a sentence as a C. Did the judge talk about that? The fact that, in a sense,
he got a deal.
Yes.
He did in this.
I'm not trying to suggest that it's a deal, but yes, sometimes that term comes out. So.
Yeah. Absolutely. The judge did consider, and we're not arguing, the judge is absolutely free to consider uncharged conduct if he finds that,
I was thinking more about that actually the proof might be such that a person could have been found guilty of that, but you pled to a C, so I'm going to take into consideration what your potential sentence was. And the judge talked about that some.
the judge absolutely talked about that, and I think that's part and parcel with, this was the continuous sexual abuse encompassed what the victim testified to, that this had occurred over a number of years, and that the other conduct, the other sister testified, his stepdaughter and the other sister testified that to similar behavior. So it absolutely was considered.
All right, thank you.
If the court has no further questions,
Let me ask you one more. Is the defendant arguing that the trial court's ruling did not rise to, or not have the findings to support a review, that this is a issue of reasonableness under bias, or that this should be a de novo hearing because he did not make those types of findings?
it would be an abuse of discretion, namely that the trial court made an erroneous assessment of the proof, and at that point that would trigger the de novo review, and this court under de novo review should reverse and remand for either consideration of the proof under an appropriate context, or if the court finds from the record that there's enough to do either split confinement or a probated sentence. Thank you, Your Honors, and I'll rest of my remaining time. Thank you.
Morning.
Good morning, and may it please the court, Caroline Weldon on behalf of the state. This court should affirm the trial court's order of confinement because the trial court properly considered the purposes, principles, and other relevant provisions of the Sentencing Act, and substantial evidence supports the trial court's findings regarding the need for confinement. The defendant sexually abused his minor stepdaughter, AMR, from September 2011 until March 2018. The sexual abuse began when she was 10 years old and occurred nearly weekly for that period of time. The sexual abuse involved grabbing her chest, touching her vagina with his fingers and his penis, as well as forced fellatio and cunnilingus. The defendant pled guilty to a reduced charge of sexual battery by an authority figure in return for a sentence of 6 to 10 years, with the manner of service to be determined by the trial court. After a lengthy sentencing hearing involving a host of witnesses, the trial court found that the defendant should serve a mid-range sentence of 8 years in the Tennessee Department of Correction. The trial court considered the report prepared by the Tennessee Department of Correction, as well as the victim impact statement, sentencing hearing testimony, and the purposes of the Sentencing Act, as well as the defendant's specific conduct in this case. With respect to the length of sentence, the trial court applied enhancement factor 1 and found that a history of criminal behavior was enough to establish the range, and expressly found that the defendant had sexually abused both of his stepdaughters, even though the conduct towards one of those stepdaughters was uncharged. The trial court also expressly found that even though this was the defendant's first arrest and first conviction, that the absence of a criminal history did not mean that he had abstained from crime, because indeed he had committed crimes during this period of time on a weekly basis. As the court noted, the victim testified that she had suffered greatly from this conduct, and that she had been diagnosed with depression as well as post-traumatic stress disorder. And the court also noted that her innocence had been stolen as a result of this conduct. Although no serious bodily injury occurred, the court assigned little weight to this mitigating factor. And again, the trial court noted that this was the defendant's first arrest and first conviction. With respect to the manner of service, which is what this case really turns on, the court found that the defendant was not amenable to rehabilitation. And part of its finding as to that lack of amenability is his lack of honesty with Dr. Adler or the court about the nature of his offense. Dr. Adler interviewed him, and the defendant minimized his conduct and attempted to cast his stepdaughter as almost the sexual aggressor in this, during this sexual abuse. He described that his stepdaughter approached him while she was topless and that she had put her hand on his penis, suggesting that she was in some way culpable for his own behavior. He also described the conduct as inappropriate touching, which certainly is a minimization of what actually went on inside that house. With respect to the depreciation of the seriousness of the offense, the trial court seemed persuaded by the defendant's use of manipulating his then wife's work schedule so that he had privacy with the children, as well as directing the third child, the brother of these two sisters, from the home so that he could have privacy with them and so that he could abuse both of them. Again, the abuse lasted for a very long time. It occurred on a weekly basis, and it involved very invasive intrusions on the bodies of these girls, and specifically the victim, AMR. And it did not end until AMR was emancipated and actually left the house. With respect to Dr. Adler and his report did not rely solely on the defendant's interview and his acknowledgement of his, as he puts it, inappropriate touching of the victim. He also considered a host of collateral sources in preparing his report, and the trial court noted these when it eventually determined that he disagreed with Dr. Adler's assessment of the defendant's ability to be released into the community as a low, moderate level offender. If there are no further questions, the state would ask this court to affirm the sentence imposed by the trial court.
All right, thank you, General.
Thank you.
Rebuttal?
Your Honors, we would just reiterate that the trial court is under bias free to give whatever weight that it deems appropriate to the factors that it's required to consider. The trial court is there, the trial court can see the witnesses, the trial court can make determinations that a reviewing appellate court that we cannot, that unless they jump out from the page at us, they're going to have more ability to judge whether or not somebody is someone whose conduct the public needs to be protected from or needs to be punished because of the egregiousness of the offense. We're not disputing that Judge Freiberg did not consider everything that he was supposed to consider. What we are saying that the trial court was not free to do is make findings such as it did in this case that are not supported by A, Dr. Adler's report, B, the testimony of the community or the witnesses that Mr. Wells presented, and that would have a chilling effect if it considered defendant's witnesses as that discrete community and establishing that factor to be protected. And it's also not free to characterize something as egregious without something necessary beyond what is necessary to establish the elements of the offense. So it is important in this case, although the facts are not great and they're not good facts, that the proof that was tendered at sentencing was not as the trial court stated it to be in its order, and then relying on that, the trial court made an erroneous assessment of the proof and thereby abused its discretion. And for that reason, we would ask this court to apply de novo standard of review and either send it back to the trial court or make a determination from the record that Mr. Wells is entitled to a sentence of split confinement or suspended sentence. Thank you, Your Honors.
Thank you. Excellent briefs by both sides, excellent arguments. We'll take the case under advisement and call the next case, please.